In this video, we'll discuss the salient features of India's constitution. So, the very salient features of Indian constitution, the first one is it is the lengthiest constitution, and the second one it is federal in nature but unitary in spirit, and the third one there is a parliamentary form of government, and the very head of the state, the president, is the titular head of the state. And regarding citizenship, India adopted single citizenship. And the next one, there are justiciable and non justiciable rights, and the very constitution is flexible rather than rigid, and the very ideas of centripetal and centrifugal formation of the Indian Union and these provinces or states, this idea was also another feature of the Constitution of India. So also we found another most important feature, that is the constitutional remedies or judicial reviews. And another most important feature is the feature relating to protective discrimination, and the next one is that reasonable restrictions, and another one is universal adult franchise. And so also another two important features, we found the special transitory and temporary provisions relating to some states of Indian Union, and so also special provisions relating to certain classes in India. So, if you see exactly, it is the lengthiest constitution of India. As we know, the first written constitution of the world is the American Constitution, but the American written constitution is the shortest constitution. But in comparison to American Constitution, India adopted a lengthiest constitution in its adoption on 26 November 1949, which was containing 22 parts, 8 schedules, and 395 articles. And in that context, it is otherwise called the lengthiest written constitution of the world. And another most important feature is that we found certain federal features, but also we found unitary spirit. And regarding that federal features, that we discuss in the context of distribution of powers of legislation, powers of administration, and the powers relating to finance. And as these were divided under the union list, the state list, and the concurrent list, which lists were containing certain items or subjects which over the union has the paramount power to legislate. So also those items falling under state list, the states are having paramount power to legislate. And in the concurrent list, where both this union and state have their respective power to legislate, but in case of any contradiction or conflict in between the legislation of the union and the state, then the legislation of the union would prevail. and besides that also the very power of emergency and the amending provisions and so the president's power of promulgating ordinance etc. as we found at the unitary features, and those unitary features also led to this idea that the Indian constitution is quasi-federal in nature, as it was expressed by professors Sir I. Jennings that the Indian constitution is quasi-federal in nature. And besides that, another important feature of Indian constitution is that the very government of union and even in a state is parliamentary in form. That exactly means that it is a cabinet system. So, the very idea of cabinet responsibility and individual responsibility and the very authority of the Council of Ministers, both at union and also in states, having much important power rather than the president, and as the House of People or Lok Sabha in case of union, and in case of state the legislatures or legislative assemblies are comprising the directly elected representatives of the people. So, it fundamentally established a parliamentary form of government in India. And as regarding the head of the state of the Indian Republic is the president, is a titular head, as the president has all the powers. Besides that, there is a lot of limitation that it would be only enacted by the legislature and it would be implemented by the executive, that is the council of ministers. So also the president could be impeached by the parliament under the procedure of impeachment. So all such powers in the hand of parliament or the union legislature and the council of ministers at the union, it expresses that the head of the state or the president of India is only a rubber stamp. And besides that, Indian union comprises a single citizenship, that anyone in India, any person as an inhabitant of the Indian territory, he first is a citizen of India, and this came into conflict with the American system of dual citizenship. As in United States of America, a person is first a citizen of a unit or a province, such as you can give an example as regarding the state of California. So, any person living in California is first a citizen of California, then a citizen of United States of America. So, they adopted dual citizenship while our constitution adopted single citizenship. Only exception was there, the state of Jammu and Kashmir, under the very provisions of Article 370 of the Constitution, and which was removed recently in 2022 by the Union legislature and by the Union government under a act by removing the very article from the constitution. So at present, even these persons or citizens of Jammu Kashmir are fast the citizen of India. So in India, there is the prevalence of single citizenship as compared to United States of America, where there is double citizenship or dual citizenship. And as regarding the next important feature, that is relating to justiciable and non-justiciable rights. As to justiciable rights, these are those fundamental rights which are included under Part 3 of the Constitution from Article 12 to Article 35, and these are the justiciable rights as these rights are enforceable under court of law as itself it is provided under Article 32 of the very Constitution of India, which itself is a fundamental right, and also Article 226, which also falls under those justiciable rights as in case of high courts. And regarding non-justiciable rights, Part 4th of the Constitution, which consists the directive principles of state policy, which are the goals of the state, and these non-justiciable rights are not enforceable in any court of law. And the next important feature, that is regarding flexible and rigidity. And as you will know, in case of India, regarding enactment or amendment of the very constitution, it requires the very signature or signatory of any amendment by one half of the states of Indian Union in comparison to United States of America, where the very amendment of any provision of the Constitution required third, three-fourth signature of the units of United States of America. So the very amending provisions as provided under Article 368 of the Constitution, as we examine and analyze those amending provisions, it indicates that our Constitution is more flexible than the American Constitution, and which is completely rigid in regards to amending the very constitutional provisions. And the next feature, that is the centripetal and centrifugal ideas. As this we discuss, the Indian Union was formed by merge of Indian princely states and units, and these are otherwise called by merger of different states or units into the Indian Union as it was formed through it is a method of centripetal formation of the Indian Federation. And as regarding to centrifugal formation, as we could cite the very formation of recently certain new states like Jharkhand, Chhattisgarh, and Telangana, which were created by the method of centrifugal by dividing certain states, existing states like Bihar, Odisha, Madhya Pradesh, and Andhra Pradesh. So these are the other important features which are otherwise known as centripetal and centrifugal ideas behind the very formation of Indian Union, and also regarding formation of new states, which we would like to discuss in detail when we will go to that chapter, and regarding constitutional remedies or judicial remedies, as we found under Article 32 of Part 3, which itself is a fundamental right. It relates to judicial review of the legislative acts and the executive and administrative actions by the Supreme Court. So also, under Article 226 of the Constitution, the very constitutional remedies were provided to different high courts in relating to violation or infringement of fundamental rights. And the another most important feature is protective discrimination. As we discuss, Article 14, 15, and 16 of the Constitution, as it is explained about not having any discrimination of any kind, and besides that there are certain provisions which provides that state can make discrimination for the development or improvement of certain classes of people, such as children, women, or backward sections of the community or society. So, this is otherwise called protective discrimination. And under protective discrimination, we could analyze the very reservation provision to the scheduled caste, scheduled tribe, and socially, economically, educationally backward classes, and to even to the minorities. So, besides that, another important feature is the reasonable restriction. So, all the rights and freedoms available under Article 19 has itself certain restrictions imposed, such as regarding the speak, right to speech, and right to assemble, and right to move freely, and right to form any union or association, and right to carry on any business, commerce, trade, etc., and all regarding these freedoms as provided under Article 19 are itself have reasonable restrictions. So, this is another important feature of the Constitution. And the next one is universal adult franchise. So, all those who are major under the Indian Majority Act of 1875, so they were given the right to vote, and under universal adult franchise as provided under the very provision of Article 326 of the Constitution, all are without any discrimination or without any disability are eligible to exercise their right to vote, and this is otherwise called universal adult franchise. So, besides that, another two important features are the special, transitory, and temporary provisions relating to some state. So, this falls under Article 370 and Article 371 of the Constitution, of which Article 370 was removed or eliminated recently that relating to the state of Jammu and Kashmir by the Parliament of India with the Union government, and regarding Article 371, these special transitory temporary provisions are also relating to the northeastern states like Arunachal Pradesh, Tripura, Sikkim, Manipur, Meghalaya, Nagaland, etc. And as regarding the last important salient features, that is relating to special provisions to certain classes, and where we could examine and analyze those ethnic tribes remaining and inhabiting in different parts of the Indian Union in different states. So, also other different classes of tribals and other categories of inhabitants living in other parts of Indian territory are considered as the certain classes which are enjoying special provisions as per the Constitution of India. So, in our upcoming video, we will discuss regarding incorporation from other constitutions.